All right, so we're back. If you go to Statsky on page 4, there's a little assignment which I transferred over here. And it talks about different sources and kind of what applies to them. But I wanted to go through these sources first and first like talk about what is primary and what is secondary law. So primary law is, the law, right? A law promulgated by some sort of government authority. So administrative regulation would be primary. Administrative decision would be primary. A charter. So a charter is like the establishment of a government, the Magna Carta, right? So that's a primary law. Constitution, primary. A legal dictionary, a legal encyclopedia, those would be secondary sources, secondary authority, because they are not promulgated by any, governmental entity. An executive order, primary. An attorney general opinion, I know they have it in Statsky. It's kind of like a hybrid. It is a governmental official, but it does not have a binding authority on anybody. It's just advisory. So it's kind of doesn't even really belong here. But a case, court opinion, that's primary law. An ordinance is put out by a city or a town government. Okay, so that's a primary authority. Periodical? No, that's secondary. Rules of court, yeah, those are binding rules of civil procedure, criminal procedure, things like that. So those would be primary. A statute, primary. Treatise is a book or a volume of books that talks about a particular area of law. So that would be a secondary source, written by a scholar, not written by a governmental entity. And then a treaty, right, is a party, an agreement between two nations. So a treaty would be a primary form of law. Okay. So we went through secondary. We have those: dictionary, encyclopedia, periodical, treatise. Written by a branch of the city government. The only one here would be the ordinance, right? Because the other ones are different branches of government. Applied by courts and opinions. Oh my gosh, there's so many, right? So a chart, administrative regulation, yes. Charter, yes. Constitution, yes. Executive order, yes. Case opinion, yes. Ordinance, yes. Rules of court, yes. Statute, yes. Treaty, yes. A fundamental law, that would be like a charter or a constitution written by the legislature. Statute, rules of court, and that's it. So just a fun little exercise to kind of reinforce what we're trying to figure out, what these things mean and their levels of authority. Okay, so where do we find them? So our code books, our statutes, and we had some pictures of them last week. In print, we have our code books. So for Illinois, we have our Illinois compiled statutes annotated. For the online, it would be, you have free internet sources like our federal or state legislative sites, Legal Information Institute, and then our paid databases like Lexis, Westlaw, Fastcase, things like that. Same gig for case law. So cases are in Case Reporters, and then we have free internet sites like Google Scholar, which you learned about last week, and some court sites have cases, and then our paid databases like Lexis, Westlaw, Fastcase, etc. Oh, and here we can play a little bit of the primary, secondary game again, but these are places we would go. All the places you'll go to get our legal research. Okay, Case Reporters, we find our cases. Code books, we find our statutes. Digest, secondary source, helps us find the cases in Case Reporters. All of these legal encyclopedias, dictionaries, the sources, secondary sources. A loose leaf service. Loose leaf service is on a particular area of law. So you might have like the environmental law reporter might be a loose leaf service. So every month or quarter, they'll come out with updates in environmental law, new cases, new rules, new regulations, new things that are going on in environmental law. And they're updated in these loose leaf binders. Now, loose leaf services is kind of a misnomer these days because these are services that are available online. Very few people get them in loose leaf form, but that was the traditional form of them. treatises. Treatises are written by legal scholars who are experts on different areas of law. So I think in the law library, we have Williston on contracts. So Williston was some contract scholar, and he wrote a book on contract law. Form books are super helpful. How do I find a bankruptcy petition or a form for jury instructions in Illinois? Things like that. Again, a secondary source. Legal periodicals like law reviews or law journals. So out of here, yeah, this is where we'd find primary law, kind of those two. Everything else would be secondary sources. All right, so how do we navigate law books? Very similar to navigating other books. So things you can look at, a table of contents. Okay, so in our textbook, we have a table of contents. Tells us where to get, how to get to the particular areas that we're interested in. Digest, I click on here. An index. Index would be in the back, and it's like terms, and it tells you what page these terms appear on. Okay, authority, binding, page 42. That's how we get there. Table of cases. Now, I don't think we have it in our textbook, but a lot of times, like treatises, will have a list of all the cases cited to in the book and tell you what pages they appear on. Same thing as statutes. On a lot of times in the beginning of a research book, there'll be what we call prefatory material, directions in the beginning on how to use a book. What's the best way to use it? And then for currency, pocket parts. Pocket parts for print text, for print books. You have a statute that you're looking at in a code book. After the statute, you might have these annotations, little summaries of cases that have interpreted the statute. And then you're done, but you're not done because you look in the back of these bound books, they're pockets. And in the pockets, there may appear a little soft covered insert, which is called a pocket part, with new additions on, maybe new annotations or new updates to the statute. And I have a separate video on what a pocket part looks like. That'll be in the supplemental video section of this learning module. So watch that. And pocket parts is always a quiz question. And I talk about it and I tell you it's going to be a quiz question. And like 50% get it wrong every time. So don't get it wrong. Free internet searches. So we have like all these primary sources of law we can find on government sites, like, the legislature will have their code, but sometimes it's harder to find those materials. They might not have full text searchability. They won't have headnotes if it's a case or annotations. It's there, but maybe not always so user friendly. Then we have our paid internet databases like Lexis and Westlaw that are through a paid subscription, which they make it easier for you to find things and understand what these laws are saying. Annotations, headnotes, some editorial enhancements. You can save your research in these databases. So that's why you pay for them, I guess, because they give you a lot more. All right, so we were talking earlier before we start our research, we have to know, is it state, is it federal? Another question to ask, is it a civil issue or a criminal issue? Because there's different areas of law, there's different burdens of proof, there's different rules of court relating to civil cases, which is just, Joe Schmo suing Jane Schmo, asking for damages. Criminal cases is where a government is bringing a governmental entity, state's attorney, people, they're bringing an action against an individual for a violation of what we call the criminal code. And in the criminal cases, one of the potential options for the defendant is to go to jail. Okay, so any case, though, your resolution comes in what we call a judgment. The judge makes a decision. It's a judgment for plaintiff, judgment for defendant, judgment of guilty, judgment of not guilty. So very similarly to the way our research process goes, judicial process goes. process by which they make their decision. They review their facts, they review the law, they compare the law to a particular set of facts. They see, are there cases that are precedent to them, are binding on them? How close are those sets of facts to the facts that they're looking at? And then they make a judgment. And they do talk about it in the book that judges, just like anybody, their decisions can be influenced by their politics and belief systems. We were talking about the Supreme Court nomination process, or I was talking about it, and how it's very heatedly debated, and people are worried about the judicial beliefs, the belief system of the person being confirmed, because it can influence their actual judicial decisions. Okay, we talk a lot about litigation when we're doing our research. Litigation is just two parties disagree to the point where they bring their problems to court because they can't figure out a way to resolve it on their own. All the parties to litigation are called litigants. You have plaintiffs on one side, defendants on the other side, but they're all litigants. And even before you file a lawsuit, it's called litigation. When you're in this, negotiation, settlement, investigation, it's still called litigation. And there's a lot of parties like to settle because it saves lawyers costs, it avoids publicity for a defendant, and you avoid some sort of super unfavorable result on either side. Laws are made by a lot of the branches of our government, right? We have our legislative branch that's what they do. They make laws. Our judicial branch makes laws through their case opinions. And then we have our executive branch, and the executive makes law through executive orders and through the administrative branch of the government, or their administrative arm, their agencies. I think we mentioned this last week, but there is a difference. We have civil cases, we have criminal cases. We also have courts of equity, or which are also called chancery courts. And the big difference between chancery courts and law courts is that the damages sought in chancery court are equitable damages, we call them. We want an injunction. We want somebody to do something. We want somebody to stop doing something. We don't want money for breach of contract. We want them to actually perform that contract, which is called specific performance. The concentrates not so much on the letter of the law, but on principles of fairness to both parties. Okay, one of the terms that you researched last week was jurisdiction, which is the power over a court to hear a case. You have geographic jurisdiction, right? So I can't be from Alaska and then file suit in Illinois if whatever dispute has no foundation in Illinois. Subject matter. So some courts have powers over, like the tax court would be limited to tax matters, or family court or something along those lines. In personam, they have to have jurisdiction over me personally. Again, if I never did an action in Wisconsin, I shouldn't be able to be brought in to Wisconsin to defend myself in court. There's other types of jurisdiction, courts of limited jurisdiction, like tax courts, family courts, bankruptcy courts, exclusive jurisdiction, concurrent jurisdiction, where two courts may have jurisdiction over the same matter. Jurisdiction is super detailed. I mean, I took a whole semester, well, almost a semester, it seemed like a semester. It was like a month that we just talked about jurisdiction. So when you file a court, that means you're filing it in the case of initial jurisdiction. And then if there's an appeal, you have to see if the appellate court has appellate jurisdiction. And take a look at the charts on page 20 and 21 in Hamies that talk about, and state what's your court of original jurisdiction and what the appellate jurisdiction courts are. All right, we're going to talk a lot more about citation next week. But remember that when you are writing anything in legal writing, you need to make sure that it is supported by law. And then you state that this is the law, and then you give the citation. You do not put it in a footnote or an endnote. It goes right there in the context of your writing. The court doesn't care what you think is the best idea. It only cares about legal authority. So you say the rule is X, and then you cite it. Okay, we talked about case reporters, the books where court opinions are found. But this talks a little bit about which, the different case reporters for different jurisdictions. So for federal, these are your case reporters. Federal supplement are the trial court ones. Appellate courts are the federal reporter. And there's 3 editions of it. You have the federal reporter, the federal second, and the federal third. F2, F3, F third. Okay, and then the Supreme Court, look, you have 3 books, 3 separate volumes of case reporters. And it's important to know that the U.S. reporter is the official reporter. So when you're doing your citation, you have to know which ones are the official reporters because you have to give a minimum of the official reporter in your case citation. So that's abbreviated U.S. Then there's the Supreme Court reporter and the lawyer's edition reporter, which are, printed by actual publishers, not the U.S. government. Now, Illinois, our unofficial reporters, the Northeast reporter, which is called like a regional reporter. So it'll have like Illinois, Michigan, Wisconsin, Indiana. And so it has more than one state in it. What we have in our library, which when we get to our library, you will see are the Illinois decisions, the ILDEC. And again, those are unofficial. Our official ones, after 2011 is an electronic citation, which I'll talk to you about next week. Before 2011, for Supreme Court decisions, Illinois Supreme Court, you had the Illinois Reporter, which was ILL or ILL2D for the second edition. And I think there's actually an ILAP third. For the appellate court reporters, you have the ILAP, ILAP second, ILAP third, different editions of that. To find, so court opinions are chronological, so we use what's called digest to find them. And I think 3 weeks, a few weeks down, we're going to look at that. But when we're looking at our cases and we look at our head notes and things like that, it will be, you'll start seeing what we mean by digest. They're indexed, and you look through the index for a topic, you find the key number, you pull your cases. We'll go over it. It's a big thing. And this is just an intro here for legal writing. For any time we're going to be doing legal writing, we're going to use this general format, which is in the beginning of the Hamies chapter. We put out our facts. We identify our legal issue. If there's more than one legal issue, we say that. Then we put forth our rules. What are our laws that we're relying on in this legal writing? And then our analysis is where we apply our facts to our rules. And then our conclusion, which we come up with our legal conclusion. So we'll be working on that all semester. Oh, and then at the end, the Hamies, page 16, test yourself, 40E, just look at that to see, start thinking about what's a state law issue and what's a federal law issue, to kind of test yourself. And the answers are in the back of the book on that one. All right, so look at the supplemental videos. Don't forget that we have a CALI lesson to do, and look at your homework. The homework is in the Stasky book, but you have to look at, I gave you links to find the cases that you need to look at because we don't have books here. All right, you have a great week. Reach out to me if you have any questions.